A U.S. Supreme Court request to the parties in a Louisiana redistricting case could affect Alabama's similar long-running battle over congressional boundaries. Justices are asking parties to address whether the state's creation of a second majority black congressional district violated the 14th or the 15th Amendments. Experts say the move could signal that the U.S. Supreme Court is looking to overturn Section 2 of the 1965 Voting Rights Act, which forbids election laws that discriminate based on race, color, or membership in language minority groups.
We're going to bring in our chief legal analyst, Khalif Rhodes, for the final time this morning. Khalif, the Voting Rights Act, something that was needed, particularly in the South. You've talked about history today. There's a reason why the Voting Rights Act was put on as law. What could the Supreme Court do here, and how could that dismantle everything that the VRA does?
Well, I can tell you what the Supreme Court wants to do. I'll take folks to history and law school at the same time.
Yeah.
First of all, Clarence Thomas wants this case so bad. I mean, he's biting at the bit to get to this case, because back in June when they were attempting to resolve it, and they set it for this hearing date now, Clarence Thomas wanted to actually have a hearing on the merits, and he said it makes no sense to not address the underlying issue, which is the Voting Rights Act. He has systematically attempted to gut the Voting Rights Act since he's been in office, most recently getting rid of Section 5. That's the pre-clearance requirement, and now going after Section 2. I'll touch on what you mentioned in the opening about Voting Rights Act and its necessity in the South. Well, when I lived in Michigan, I also recognized that there was a necessity in the North, because in the Voting Rights Act, it says in the South, in the southern states, it lists Georgia, Mississippi, all these other places. But then it also lists a couple counties in the state of Michigan. Why? Because the facts show, and that's why I would go to my first point, history made it sure that it was a necessity to have the Voting Rights Act, because in certain counties in Michigan, they were systematically going against African Americans to ensure that they couldn't vote. So 1870, 15th Amendment was ratified. What happens then? States quickly go to these race-neutral devices, literary tax, poll tax, at-large voting systems to get rid of and dilute the black vote. 1960, Congress had a mountain of information to show that there was an extensive record of systemic racial discrimination in voting. 1970, 1975, 1982, 2006, they reaffirm and reauthorize the voting rights of the Voting Rights Act. And then in 82, they adopted this thing, and this is what they'll address in this court hearing, the results test. Clarence Thomas believes that, first of all, the Voting Rights Act should be underneath the Constitution and the Constitutional Amendments. While I agree with that, he also does not understand and does not appreciate the fact that there needs to be a Voting Rights Act, because he thinks it violates 14th and 15th Amendment. So there are a number of things that he's attempting to address, and the results test is something that he will point to as a reason that is now unconstitutional.
Khalif, this goes beyond just the boundaries of Louisiana, right? I mean, this could certainly affect all the states. What is at stake here for democracy when it comes to communities being able to elect leaders?
Well, it's ensuring that you're not discriminating against folks and not giving them an equal opportunity to vote. And so when you have things like where South Carolina, for instance, 1966, the court said the Voting Rights Act was appropriate exercise of Congress's abilities to ensure that states wouldn't manipulate maps. So it's not just Louisiana, who multiple times the courts have told them to go and draw your maps in a way that ensure that there are 2 congressional districts that at least allow African Americans to have an equal vote in their state. So Louisiana has failed to do that. They've been taken to court multiple times. So the impact is a couple things, specifically here in North Carolina, where we're not new to drawing maps that have constitutional challenges. I think something like this, specifically if you gut out the Section 2, it will have a terrible impact, a monumental impact. I can't think of any other word to describe the size of the impact that it will have on how states can now do whatever they want. I'll roll it back. Section 5, the pre-clearance requirement. That was because we knew that your state was so unfair to African Americans. Before you can make any changes in your state, you had to get Department of Justice, get authority to make changes. Removing that pre-clearance was the first step to eroding the things that were put in place with the Voting Rights Act. So now Section 2, if you remove that, it's going to be the wild, wild west of the map drawings in our country.
Khalif, you got 20 seconds here. How do you think the Supreme Court rules?
The lower court ruled in favor of the folks that were moving and wanting them to draw the maps constitutionally in favor of the African Americans. The Court of Appeals in that same region did the same exact thing. The Supreme Court, based on what Clarence Thomas has said and based on the numbers, I think they rule against 60 years of precedent. I think they rule against the other two courts and remove Section 2 like he wanted to do almost 2 years ago.
Queen City News Plus. Just search Queen City News on your smart TV's app store.